Next case set for oral argument here this morning is Amanda Gain versus Joel Gain. It's case number 21CA011736. We have Attorney English and Attorney Nickel presenting their arguments today. The panel will be myself, Judge Teodosio, as well as Judge Callahan, who I believe is going to be kind enough to keep track of time for us. Is that correct, Judge Callahan?
That's correct.
All right, thank you. Also joining us is Judge Sutton on the panel. Each of you will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. So let Judge Callahan know at the start of your argument if you do want to rebut or reserve rebuttal time and how much, and she'll let you know as you get close. The arguments are being recorded, so please make sure that you keep your voice up. As you know, we have a YouTube channel, so the arguments will be available for anybody who wishes to tune in. And please do not use the name of children or minors or victims during the argument. We prefer and require that you refer to them by their initials or the child. And you both are well aware of that rule, having argued many times before here. Having said that, the judges have read your briefs and we're ready to proceed if you are. So the appellant is represented by Attorney English. If you'd let Judge Callahan know if you're going to reserve time, and you may begin.
Thank you very much, Your Honors. I would like to reserve 4 minutes of my time for rebuttal. Thank you. May it please the court, my name is Brent English. I represent Amanda Gain in this appeal. The facts in the case are critically important, so I want to review them. Even if you may have read the briefs, I want to make sure that the court has an understanding of what the facts are. In July of 2017, my client, Amanda Gain, filed an ex parte motion for a domestic violence civil protection order in the Court of Common Pleas of Lorain County. It was granted the same day it was filed, and as a result, the appellee, Joel Gain, no longer had any visitation with his children during the pendency of the case. There are 2 children in this case, both of whom are still minors. One is called, we refer to her as ARW and ARG, and the other is referred to RWG. ARG is a female child, and she's younger than the other child. In any event, there was a full hearing that was conducted by a magistrate in the Court of Common Pleas on the domestic violence civil protection order over several days. And I don't mean to say full days, but they were portions of days. And ultimately on October 17th, the magistrate issued the following order. She determined that the civil protection order should be granted or should be sustained with respect to the oldest child and for a period of 5 years. And she failed to mention, much less make a finding about the youngest child, period. She did not say that the civil protection order was granted or denied. She did not do any of the requirements of Civil Rule 65.1, which is applicable to this case. As a result, the parties were in the following position. There was an ex parte order that had been issued, which was still in effect until such time as the court ruled on the substantive motion, the motion for a petition for a domestic violence civil protection order, and the court had not ruled with respect to the child. Mr. Nickel, on behalf of Joel Gain, then filed a motion in an unrelated case. It's the same parties, but a totally different case number, and in the Court of Common Pleas of Lorain County Domestic Relations Division, seeking to hold my client in contempt for failing to abide by the former visitation order, despite the fact that there was still an ex parte CPO in effect. as soon as he filed that, we filed a motion to dismiss on the grounds it was apparently, at least it was obvious only to me, that the court had no jurisdiction to do anything in terms of finding the client in contempt, when in fact there was an existing CPO that had still not been decided. There was finally a brief filed by Mr. Nichols with respect to the matter, and ultimately the trial court decided that the decision rendered on October 17th, 2017, should have been either a motion for reconsideration should have been filed, objection should have been filed by my client, or an appeal brought by my client, even though we agreed totally with the decision. And we pointed out repeatedly that there had not been a decision with respect to the CPO in regard to the youngest child.
Mr. English?
Yes, Your Honor.
So just to clarify a little bit more on that point for me, if you could, you said that you agreed with the decision, and as I understand, no objection was filed. But in that decision, AG was it AG? The minor child was not included. So were you in agreement with the magistrate's decision or not?
Well, we were in agreement that a 5-year CPO should have been issued with respect to the oldest child, and we recognized that the court had not yet decided whether or not a CPO was necessary in regard to ARG, the youngest child.
And did you file an objection then related to the youngest child, ARG, to the magistrate's decision?
No, Your Honor, we did not. We had no objection to it because we anticipated the court would, in due course, make a decision with respect to ARG. And we invited the court to make that decision. We raised the issue over and over again, and the court never made a decision with respect to ARG. Instead, it concluded that by virtue of not mentioning ARG in the October 17th entry, that sub silentio, the court had overruled the motion for a CPO with respect to the youngest child. But there are many problems with that idea. First of all, if it is a judgment, unquestionably, the law provides that it has to be articulated clearly so that the parties can understand what their rights are, whether they want to file objections, and as you know, there's an unusual provision in 65.1. The case law has established that you can file objections, but essentially they don't matter because you must file a notice of appeal, or the objections are essentially irrelevant. That's very unlike what happens in Civil Rule 53 proceedings, where you file objections within 14 days, and if the objections are overruled, then you may appeal. But
Mr. English,
yes,
if I might ask you, the DVCPO, the entry that's issued by the court, it states persons protected. Is that correct?
It does.
And then in the case that issue before us, it had wife/mom and then one other child, correct?
Correct.
It was sought for mom and 2 children. Persons protected ended up being mom and 1 child. I guess my question is, what wasn't clear about that?
Well, what wasn't clear is that there was no indication whether the child ARG was protected or not. She was not even mentioned in the judgment entry. And it's unreasonable.
Isn't that pretty clear?
No, it wasn't very clear at all. Particularly since the law requires that you state whether or not a person is protected or not. And unequivocally, 65.1 requires you to say whether or not you are protecting a child or not. If the court had said that, then we would have had the appropriate appellate and/or objection rights that existed. But it's ambiguous at the very least. And in my opinion, it is very clear that the court had not yet decided the issue with respect to ARG. And we raised that issue early on. And the court could have immediately resolved this by saying, I'm sorry, I intended to say that ARG was not a protected party. And therefore, we'd have been in a position where we could have challenged that either by objections or appeal, assuming we wanted to do that.
Mr. English, I'm
Yes,
sorry,
Dr.
I seem to recall in something that I read in the record here that wasn't there some comment made by the magistrate specifically related to the one minor child not being protected? Or am I incorrect in that? Prior to the issuance of the October 17th judgment.
I'm sorry, Your Honor, I'm not understanding that question.
Okay, I believe I read somewhere in the record, maybe in the trial court's order, that the magistrate during the hearing conducted on September 24th, 2018, specifically stated that the minor child was not a protected party under the civil protection order. Did that happen?
That is the conclusion that the magistrate that handled the contempt issue made. However, that assumes that as of October of 2017, the court by sub silentio decided that ARG was not a protected party when in fact it never made that decision at all. This is a matter of elemental due process. If in fact the court is going to deny a civil protection order for a particular party or child, it must state that. It doesn't have to provide a rationale, but it at least has to state that. That's what 65.1 expressly requires. It can't just leave the matter open and subject to potential interpretation so that a client like mine, Amanda Gain, is now subject to a contempt proceeding for not complying with an additional court order that is clearly by operation of law suspended as a result of the CPO. In addition,
Now this situation's a little bit, it changes a little bit in July when the ex parte order would have expired as to ARG, and wife still allegedly did not provide visitation or parenting time with husband.
yes.
And Mr. English, I'm sorry to interrupt with that question. I want to let you know you're going into your rebuttal time now.
Okay, well, let me answer the question. I'll forsake my rebuttal time to that extent.
Okay.
Your Honor, that's correct. As of July 5th of 2018, the ex parte civil protection order expired on its own terms. However,
Right.
Amanda Gain filed in advance of that date a motion to extend the CPO for a further period of time. And she had a lot of justification for that. And she submitted that to the court. The court, remarkably, did not consider that motion at all, has never ruled on that motion, basically just didn't either see it or ignored it or otherwise failed to rule. So part of her defense in the case is that she had a good faith belief that allowing the father, who has clear bipolar disorder that's untreated, to have visitation. The facts are that the children both alleged terrible physical abuse as a result that caused the initial CPO to be granted. That evidence was in front of the magistrate, who never, and I mean never, decided anything regarding that. He did not determine that it was a good faith belief or it was an inappropriate belief. He just never mentioned the issue at all. And so it is a proper defense to a contempt, as this court has found in a number of cases, all cited in our brief, that you may not find, or the court may consider a good faith belief as a defense to contempt. But in this case, the magistrate failed to ever consider that, in fact, failed to even mention it. And as a result, we submit that the judgment is erroneous and it must be reversed. So for those reasons and all the other reasons set forth in our brief, we urge the court to reverse this judgment. Thank you.
All right, thank you, Mr. English. How much time does he have left, Judge Callahan?
1 minute and 19 seconds.
All right.
All right, that'll be your rebuttal time. And Attorney Nickel, are you prepared to proceed?
I'm prepared, Your Honor. Thank you. Attorney Wayne Nickel, good morning, everyone. I'm here on behalf of the appellee, Joel Gain. It sounds like there's two appeals going on almost, the appeal of the civil protection order issue and what really is before this court, which is whether or not it was appropriate to find Amanda Gain in contempt of the court's orders regarding my client's parenting time with the minor child ARG. I would submit to the court, and my brief points it out, but Mr. English continues to make this argument that the court never ruled with respect to ARG and continued to refer to her as a party. She's not a party. If you look at a civil protection order, whether it's an ex parte order or whether it's a hearing or a full order after a full hearing, or whether it's a consent agreement, there's a petitioner, in this case, Amanda Gain. There's a respondent, in this case, Joel Gain. And then to the right, it says persons protected by this order. And I think Judge Callahan, you pointed that out, that it's persons protected by the order. It's not parties protected by this order. And then it goes down and lists the petitioner, in this case, Amanda Gain, and then petitioner's family or household members. The statute is specific that only family or household members can be listed as protected persons, not parties. So you may have a case hypothetically where there's 10 children that are listed as protected persons, but it's the petitioner that is the party to the action. I think that's an important distinction because Mr. English keeps arguing that all of the claims were not decided regarding all of the necessary parties in this case. Yes, it was. The magistrate in ruling listed the party of Amanda Gain and then listed a protected person of RG. I call him RG in my brief. Attorney English calls the minor child RWG, and does not list, after hearing days of testimony in a civil protection order hearing, does not list ARG as a protected person. So I think that distinction is very important in deciding Mr. English's argument regarding whether or not the trial court in the civil protection order case, and again, we're not here in the civil protection order case. That's presumably the defense to the contempt, but that case wasn't appealed. And I believe Judge Sutton or Judge Callahan, I forget which one, pointed it out. That could have been appealed, that decision in listing Amanda Gain and RWG as a protected person and not listing ARG as a protected person, that could have been appealed. It wasn't appealed. So that appeal time had run, I believe, well, there was no appeal filed. So when I was going to say at the time that Mr. Gain filed his first motion to show cause. Now, the first motion to show cause was filed after October of 2017, when Mr. Gain was to resume his parenting time with ARG. And it's important to note, and I pointed out in my brief, that the parenting schedule for these two allowed for no contact, basically. My client was to pick his children, but at this point his child, up at the school that she was attending. So he didn't even have to have any contact with her. He goes to pick her up at the school, and guess what? Amanda Gain disenrolled ARG from the school. So if she thought that there was still a civil protection order in effect, why, and I asked this question of her in the hearing, and it's in the record, Why would she take her child out of the school? If a CPO was in effect protecting her child, there'd be no reason to remove her from the school, but she did, and she admitted under oath that she did it to prevent my client from having parenting time with his minor child. Now, the second motion to show cause that was filed was assuming if, as I think at the time, maybe the court hadn't ruled on the motion to dismiss. But there was this argument out there that the CPO was still in effect as to ARG. By the way, we maintained throughout, and the trial court agreed with us that it did not exist as it relates to ARG, but assuming it did, and the court said, Mr. English, we agree with your argument, that ex parte order ended in July of 18. So Mr. Gain was to resume, and I believe at the time had a week on, week off parenting with his minor child, ARG. He didn't receive that parenting time. So a second motion was filed. So now we have two contempt motions. Litigation proceeds, and Mr. Gain had to file, and this is in the record, a petition for writ of habeas corpus. That was discussed in the hearing for the contempt hearing. She was not going to follow the court order, even after this ex parte had expired. Mrs. Gain could have, but did not, file something with the court demonstrating that she's fearful that Mr. Gain shouldn't have parenting time. Instead, she just continued to ignore the order. So to say that she has a good faith defense to these contempt proceedings is just not supported by the facts. With regard to her request, and I don't know if this is in the record or not, but with regard to her request to file an extension of the civil protection order, again, I don't know that that's in the record. There may have been mention of it during the hearing, but that would have been in the civil protection order. Local rules in Lorain County require when you file a motion other than a motion for continuance to set that matter for hearing. So to say that this motion was filed and never heard, well, they have to set it for hearing. In order for a motion to be heard in Lorain County, you have to set it for a hearing to be heard. That didn't happen. So to say that this motion is floating out in outer space here and it's never been heard, again, it wasn't procedurally filed correctly. There was no hearing set, so there was no hearing.
So let me just clarify that for myself. Are you saying the local rules would have required her to request a hearing on the motion to extend the ex parte, or is it the court's duty to set the hearing date?
It's when you file a motion, you have in my motions, for any motion that I filed post decree or during the course of litigation, you have a notice of hearing with a blank space. When you file the motion, typically you get the hearing date ahead of time before you file the motion so that it's already in there when you file it. Or I suppose you could obtain the hearing date afterwards, but it's counsel.
Okay, so I understand that, and you're saying in this case that was not part of the motion.
Did not happen. No, Your Honor.
Okay, thank you.
So with regard to, again, I think I've covered the argument regarding ARG being a party versus a person pretty thoroughly. Just the last argument with regard to the award of attorney's fees. The magistrate heard 2 days of testimony regarding Mrs. Gaines' contemptuous actions. I don't believe it was an abuse of discretion to award the attorney's fees that he did. Again, Mr. Gaines had to go through the extraordinary effort of filing a writ petition for a writ of habeas corpus in this matter. Judge Glass granted it, and he resumed parenting time with his child on that particular day that writ was filed. He incurred an incredible amount of attorney's fees to bring to the court's attention that Mrs. Gaines was violating the court's orders. And I think any award of attorney's fees that he was awarded was certainly appropriate and supported by the facts. If there's no other questions, I'm finished with my argument, Your Honors.
All right, any questions, Judge Sutton or Judge Callahan? Thank you, Attorney Nickel. Attorney English, you have, Judge Callahan, a minute.
Minute and 19 seconds.
A minute and 19 seconds for your rebuttal. Go ahead.
Okay, I'm going to be fast. First of all, with respect to the idea that my client did not have a good faith basis to not permit visitation following the expiration of the initial ex parte order. We filed such a motion. We requested such a hearing. Mr. Nickel is wrong with respect to the procedure in Lorain County in a CPO proceeding. He is citing a domestic violence, or excuse me, a domestic relations rule. He is not citing a rule that pertains to domestic violence cases. The law is clear that a person protected by a CPO may file a motion to extend a CPO upon its expiration. There's no doubt about that. Secondly, the idea that my client somehow had an obligation because she is a party and the children are not parties to file an appropriate objection, motion for reconsideration, or an appeal is incorrect as a matter of law. The court must decide the issues in a CPO under 65.1, and it must declare whether or not persons are protected by the order or not. It
And
cannot
with
do
that,
so.
Mr. English, you're past time.
Okay. Well, I urge you to reverse. Thank you.
Thank you both for your presentations today, and especially utilizing the Zoom media that we do. Court will take the matter under advisement, issue a decision in due course. Of course, the clerk of courts will mail each of you a copy of the decision on the day it's released. And as you both know, the opinions are also posted on the Ohio Supreme Court's website. With that, I'm sure I'm speaking on behalf of my colleagues. We wish you a wonderful holiday season. And thank you again for your presentations today.